Hi, good afternoon, and welcome to another Volpe Koenig CLE webinar. My name is Anna Melanger. I'm the Director of Marketing for Volpe Koenig. We're a full-service intellectual law firm in Philadelphia. And today's webinar is drafting a patent application from a paragraph. This course has been approved for one CLE credit by the Pennsylvania CLE Board. So we will stay on through the end of the webinar, and then we will report your attendance to the board, and your certificates will be issued by email. And if you haven't already downloaded the course materials, you'll see two handouts in the handout section. You'll see our presentation for today as a PDF, and then you'll see an evaluation form. We'd really appreciate it if you would download both, but send that evaluation form back to us. That's really helpful on understanding how you liked it and any kind of new topics that you would like to see. So everybody is in listen-only mode, which means you're muted. But we want to make this webinar interactive. So if you have a question, Josh will take questions at any time. Go ahead and put it into the question. There's a place to put questions. Go ahead, put it there, and Josh is happy to answer any kind of question. He'll take any questions throughout the webinar. So with all that housekeeping done, Josh, I will now turn it over to intellectual property attorney Josh Hamburger. Go ahead, Josh.
Okay, hi everybody. So I'm going to do this presentation on drafting a patent application from a paragraph. So that's just intended to mean, if you get not that much material, what do you do to draft an application? And it'll actually apply to really any situation. So yeah, so I have the contents here. So we're going to talk about, we're just going to introduce, what the subject matter is about, and talk about the audience. So who you should be, you should keep in mind who's going to be reading the patent application and reviewing it. And then we'll talk about the process. So the inventor interview, understanding the technology, and then drafting the application, so organizing the application, drafting the figures, and then how to make sure that you've covered everything sufficiently, so ways that the initial material might be insufficient. And then the last part is going to be writing for clarity, so using consistent terminology and writing for clarity, and then writing to support the claim. So ultimately, the patent application, the specification and the figures are, the purpose is to support claims, so you have to be mindful of that while you're drafting the application. So, okay, so introduction. So, of course, our job as patent agents and attorneys is to, craft this patent application, which is a legal document based on some technical information. And that information might be insufficient, and frequently is insufficient to draft the full application. Sometimes, large companies generally have inventors fill out invention disclosure forms, and those can serve a variety of purposes, but those documents aren't always completely drafted. They're not fully drafted, although sometimes they are very complete, but sometimes they're pretty short. Yeah, they might be very brief. They might be even a single paragraph or less, and they might lack critical information, and they might be insufficient for other reasons. Okay, so some shortcomings of the invention disclosure forms. So, okay, again, right, they might lack material. They might be little more than a paragraph or even less. Inventors generally are not familiar with the legal requirements that a patent must meet, and therefore the invention disclosure forms might not provide sufficient information to meet those requirements, or the information that they contain might not, while they might be detailed from a technical standpoint, they might not be sufficient to meet the legal requirements. The invention disclosure forms might also fail to provide sufficient background information, and that's fairly common. And of course, these inventors are state-of-the-art. I mean, they're working with the state-of-the-art. They are extremely familiar with the topics that they're working on, and it would probably be redundant for them to actually go over all of the background information in their invention disclosure forms. So they don't include it, and if you, as a drafter, don't take that into account, the results might be less than optimal. There other problems with invention disclosure forms include that they must present information that's too detailed and implementation specific, and this is fairly common. The inventors might go really way down too low in terms of detail, and that might not be satisfactory for drafting a patent. And you might have to take that and take a step away from it in terms of scope. And then also, it's possible that invention disclosure forms explain only by example and not through general principles. This is, I wouldn't say extremely common, but it happens where inventors will explain a technique just by showing how the data that they're talking about gets manipulated, things like that. And if you just include that information in the patent application, then that you can't really, it's very hard to derive claim language from that. So that's a way that an invention disclosure form can be have a shortcoming. So what do we have to do as patent attorneys and agents? We have to extract the information from the inventors, both from the document and from an invention disclosure meeting, and we have to craft a patent application to the greatest that is, all of these things, self-supported and internally consistent, meaning that it has all of the information necessary to describe the invention sufficiently, and that also, of course, that it's internally consistent. So, that it has its own, so it's built up from its own set of sort of terminology and concepts, and of course, it has to meet all the appropriate legal requirements, and of course, it has to be technically accurate. So hopefully, I can give you a little bit of the knowledge that I have. If I'm assuming there's some people that are very experienced here, but hopefully, if there's some lesser experienced people here, you can, hopefully some of the stuff that I'm telling you will be helpful to help you draft some applications. And yeah, again, even though this CLE is called drafting an application from a paragraph, I think that these techniques are appropriate for any application that you draft, including applications where you get a really complete invention disclosure form, because you still have to translate those types of documents into a patent application, and you don't really want to just be, copying the contents of a long invention disclosure form into a Word document and maybe changing some of the words. You really, I think personally, I personally use these techniques for all the applications that I draft. I sort of treat them all the same. If they have, whether they're complete in terms of the IDF or they're not so complete, I like to craft everything from whole cloth basically and use the same principles that I'm going to talk about here. So okay, so I have a poll here that I think Anna's going to help me out with, and it's just the poll for if you're an application drafter, what types of invention disclosure forms do you get most often? So you can read the choices. They sort of vary from very detailed to not so detailed. Sorry?
It's coming in. The responses are coming in. I'm just giving it a couple more. You can't see it, Josh? When I close it, you can be able to see it. Okay, just a few more seconds and I will close it. Okay, here we go. I'm closing it. So the results are, can you see the results, Josh?
Not quite sure how to.
Okay, well, almost half say large forms that required filing. That's 54%, and from just a paragraph is 31%. And then with complete forms that require little or no info, and the invention and what's an invention disclosure for, it was 8%. So about half have that large form answer.
Okay, fair enough. All right, so that's a pretty good it's pretty good information to get. So all right, so people get some detail, but not a huge amount of detail, but maybe the smaller, I would say it seems like maybe the invention disclosure forms that people get are kind of limited in terms of the information that they get. Okay, so let's consider how do you take that and turn it into an application. So first thing to consider is, you have to think about who your audience is going to be. So there's a variety of them. This might not be an exhaustive list. Of course, the first person that you're going to be talking to is the inventors. You want to satisfy their needs, which basically means describing the invention accurately. There's also the client, in-house counsel, so non-inventor people from the client who will be reviewing the application. Anybody who takes over prosecution, so a future prosecuting attorney or agent. There's, of course, the patent office, so the examiner and other people at the patent office, generally, maybe the board. There will be people in litigation, which I won't really go into in great detail, but you have to think about that, and also the foreign patent offices are something else that you have to think about, but I'm not going to really talk about that in great detail. So the inventors, so of course, you're talking about their invention. They have extreme levels of knowledge of this invention, so you have to make sure that you express the invention accurately. And the inventors will provide some technical feedback, but there's I kind of think that there's two types of technical feedback. There's true technical feedback, so feedback that really touch on the technical aspects, and you should definitely incorporate that, make those changes that they request and on the technical side. But there's also feedback touching on legal aspects, and that type of feedback should be scrutinized carefully, especially related to the claims, but it can even touch on stuff in the specification. Say if there's some feedback that they provide. For example, a lot of inventors might say things like, we don't want to say this because it might limit the application, but as we know, putting something in the specification alone is not something that will limit the application, depending on how you say it. Whereas, of course, in the claims are what define the invention, as we all know. So yeah, just consider those aspects carefully. So in-house counsel, they, of course, all companies have their own needs. They might have legal, technical, or stylistic needs, and may relate to any aspect of drafting. And obviously, you're going to talk to your client and figure those things out. The future prosecuting attorney. So it's important to describe the invention at a level that's lower level than what one of ordinary skill in the art would require for understanding. And what I mean by that is, you should describe more of the basics than just the level, the amount of detail that you get from the inventors, because the inventors are really one who's of ordinary skill in the art. They know it so well that again, they're not gonna provide the background material, but it's important to explain all the background material. And an example benchmark that I sort of like to have in my head when I'm drafting applications is that you describe the invention in a manner that's sufficient for a smart undergraduate student with an appropriate major to understand. So yeah, I think that's a good benchmark to use to explain the application. And the reason that you want to do that is because if you don't write the application in that way, and it's possible that whoever picks it up in the future might not understand it and might not be able to prosecute it, might not be able to make the appropriate arguments, or in worst case scenario, might not be able to make the appropriate claim amendments. And this also ties into, considering the patent examiner and people at the USPTO as an audience. You should draft the application, again, in a way that allows more, that's inclusive in terms of allowing people to understand the application. And again, an additional issue is with not going to a sort of lower level when you're drafting an application is that you might not be able to claim to claim certain aspects. And even if objectively the application provides support for a certain fact, for a certain claim limitation, you might not be able to convince the examiner that there actually is support in the application. So unless you sort of go down to sufficiently basic level where it makes sense, where everything sort of makes sense. There's litigating attorneys to consider. So, I'm not going to get into, all the detailed requirements that might arise in litigation, but, you should be aware of various requirements, statutory requirements and case law requirements. I mean, we all know about split infringement, means plus function requirements, subject matter requirements, etc. There's other 112 issues, and of course, other than just actually drafting the application, you should be, you should be aware of all the issues that can affect the validity, such as, inventor identification and IDS practice. Again, the amount of information that we discussed with this particular slide this particular group of audience is enormous, so I can't really go into a huge amount of detail. And then, of course, same thing with foreign patent offices. You should be aware of the requirements for foreign patent offices. Some of them are more common, like Europe, I guess Japan. I mean, there's other places, and it's client specific, but you have to be aware of these things when you're drafting the application. Okay, so starting the process of drafting an application. So the way that I start, and I think the way that most people start, is by talking to the inventors. You schedule an inventor interview. I personally like to schedule it for an hour. And of course, this is the best opportunity and the best way initially to get sufficient information to draft an application, especially if your IDF is short. But even if you have a long IDF, a very detailed IDF, you still want to talk to the inventors, and just to make sure that A, you understand everything, or at least the core concept initially, B, that you go through everything in the invention disclosure to make sure that there's nothing left out. You might catch some errors, things like that. So it's very important to talk to the inventors initially. Again, like an hour of expert time is so valuable right at the beginning versus any other time that you could have that discussion. And again, I always try to make sure I understand the core concepts of an invention during the interview. I always try to the extent that I possibly can during that first hour, I try to drill down on all the aspects presented in the invention disclosure form and all the aspects of the invention until I make sure that I really understand it. So again, schedule a sufficient amount of time to fully discuss the invention. Again, I use an hour. This can vary, and I think an hour is a good benchmark. If it's a simple invention and or you really are familiar with it, you can use less time. But an hour of inventor time in the beginning is so valuable for the whole for the process. I find it helpful to record the interview because often I'll pick it up in a month or two or some amount of time later, and I might forget some details or forget the whole thing entirely. And especially if there's no invention disclosure form, or the invention disclosure form is missing some information. Especially in those cases, it's good to have that recording. You might take notes during the interview, but you might not. It's just best to have that raw recording of the information. And again, during the interview, I like to make sure that I fully understand the invention. You should also go through the IDF and make sure that you understand all of the topics that are brought up. And it's possible that even after you have this initial meeting, that you might need to talk to the inventors again. Again, you should do that earlier rather than later. But I personally, when I start drafting the application after the interview, and I take the material and I sort of sit down with it and try to figure out what I'm going to do, sometimes I think I'll understand it in the interview, and then I won't, and so I'll have to sit down for an hour or two and look at the invention disclosure form and my recording and see look at some parts that might not make any sense to me, or that I might have that might be ambiguous, and think to myself, I don't understand this. This doesn't make any sense. I better go talk to the inventors, or at least send them a set of emails. And that might be necessary, but again, I try to make sure that doesn't happen initially. Okay, and then some techniques for having the interview. This sort of goes along with making sure that you understand everything. Is don't be afraid to ask stupid questions. And I remember when I started out, I really didn't want to sound stupid, so I wouldn't ask basic questions. But at this point, I don't care about sounding stupid. I just want to make sure that I draft the application correctly. So I ask a lot of stupid questions and I get the information. So I think that a lot of people a lot of people might still fall prey to this and might still sort of try to pass themselves off as more knowledgeable than they really are. And I just think that ends up just hurting you in the future. So yeah, I think that's really important. And again, asking stupid questions, asking foundational questions includes information about the context of the invention. So what system does the invention live in? What are inputs and outputs to the invention? Some things that aren't listed here include, so a lot of the time you'll get sort of a modification from a well-known technique as the invention. The invention is a new small, feature that's sort of applied to a known technique. You want to understand that known technique. So that's another thing to discuss, in the invention disclosure meeting. And one thing that's sort of related to this is that there are times that I've seen applications drafted that don't describe that background. They'll leave out the technique, they'll leave out that background technique, or they'll leave out a system. And so I call this like a floating invention, where you sort of start the patent application just with the material provided by the inventor. And that can be very difficult. That can be problematic for a number of reasons. The most prominent is that, somebody reading the application might have no idea what it's about. But also, you might need to pull in claim amendments that are related to the foundational technique or that are related to the system that it's implemented in. And so if you describe only the newness, the new part, you won't be able to do those things. So understanding the technology. So if, again, you should try to do that during the interview. But if you don't, then, after, when you start picking up the application and you start drafting, you should take a look at all the materials, make sure that you really understand it. And I like to just kind of, we can try to sort of cross-reference all of the stuff that I have until it really clicks and I really understand it in my head. And that might take a few hours to do, but it's really necessary to draft a good application, in my opinion. And again, if you don't understand it, you might have to talk to the inventors. And this is so important because it's very difficult to course correct after, if you have the wrong understanding of what the invention is and you draft a whole application, you spend 20, 25, 30 hours doing that, and it's completely wrong, and the inventors come back and they say, no, actually, this is what we really meant, then you're gonna have to spend another 20 to 30 hours. So it's best to get everything correct in the beginning. And I feel like this is a common pitfall among inexperienced drafters, is that you might, and I did this when I was inexperienced. I remember a particular instance where the inventors were not too happy with what I did, but something that people might do is really draft an application without understanding all of the material, and again, just have to do that work all again, or just have a poor quality application. So, okay, so since we're talking about starting the application, here's another poll. It's how do you like to start drafting your application? Claims first or specification first?
We actually didn't do this as a poll, Josh.
Okay.
So if you can, it
That's
actually
okay.
would have been a good idea to do it as a poll. But if you just want to put your answers into the question or chat box, that would be great. And Josh, you didn't mention how long you've been doing this.
How long? I've been doing this for, I guess, since 2006.
And about how many applications have you done?
Hundreds. I'm not sure. About 50 or 60 a year, so whatever that adds up to, probably 600 or 700.
Okay. Well, most of the people coming in are saying claims first.
Okay. Okay, interesting. So, okay, that's not how I actually like to do the figures first. That's probably specification first. But I know that people have their own. Everybody has their own way of doing things. So, all right. So, I'm going to talk about how to organize an EE patent application. So I like to organize the application according to this. So I'm going to kind of go back and forth between these slides. So first, I like to do the system and also the functionality of the system. So basically all the system elements, and also, describing the system includes saying what the elements do. And then I like to, frequently I'll reserve figures for showing kind of a graphical representation of the operations that occur. And that might be, for example, data flow or data transformation. I do some graphics work, so that might involve showing how the graphical objects are transformed. But I think it's important to include sort of, this isn't really a system figure, but it's like an explanatory figure that visually shows how the operations occur. And then I like to put at the end the flowcharts. I use the flowcharts for a specific purpose, but people kind of differ on this. But so for the system elements, you should start with a broad system diagram and then drill down on the relevant parts of the system until the invention is sufficiently explained. So this should provide the context for the invention in terms of the structure and function of the system in which the invention fits. So, you start with the general figures, you describe that system, you say what operations to perform, and this might include those, this might include the sort of background techniques that I mentioned before. And yeah, so in the course of describing the system elements, you'll say what the system elements are, and then you'll say what they do. So again, the second part, which is this sort of graphical representation of the transformation, it might be the case that a textual description of the operations is not sufficient to explain the invention clearly. And so again, I like to include these specific figures that show what happens. And then for the flow diagram, personally, I use the flow diagram as a means to support, strongly support the method figures. So I don't really introduce any new material in the flow diagrams. Everything that I say in the flow diagrams is stuff that's already been said as operations, been described as operations of the system elements. And I tend to do it sort of more generically, but with explanatory text around it. But I know some people do like some detailed flow diagrams. But anyway, this is sort of the way I like to organize it. And then another thing to consider about the flow charts is that sometimes you get these weird rejections from the examiner where they say that everything in the claim must be shown in the figures, and so a flow chart is a good way to support the claims, to meet that rule that way. Okay, so the beginning of starting your application, you might have some boilerplate to provide that background information. And it's important to select that boilerplate correctly, but it's important also to make sure that you read through the boilerplate, make sure that it includes everything that it includes truly applies to what you're doing, and also that it doesn't include stuff that's either contradicts what you're writing in that. You don't want to take boilerplate from another application that includes some information about that other application, and maybe the technique from the invention from that other application is actually different from what you're doing. So you really want to make sure, you really want to grab the appropriate boilerplate from whatever your source is, and you want to look through it and make sure that everything is appropriate for your current application. And it's pretty common to not do this. People will just copy paste from an old application and include paragraphs that are irrelevant, or wrong, things like that. And this, of course, also applies to the figures. The boilerplate is both the specification and the figures. So again, you should carefully select, edit, and supplement your boilerplate as appropriate for your invention. So drafting the figures. So actually, I like to start with the figures first. I really like doing that because to me, it like storyboards out the application. It gives me a nice flow. You should draft the figures to follow the organization this is what I do. I draft the figures in the order of that organization shown above. So I'll have those system figures that go from general to specific, and then I'll have those data transformation figures, and then I'll have the flow diagram, one or more flow diagrams. And again, the block diagrams will show the system elements. Again, the figures will show the data flows. You should probably state that they're, they will show you. You can do them in two ways. You can do them as sort of depicting generic data flow, or you can do them as depicting an example data flow. And the way that they're different is the generic data flow won't include specific kind of values, for the information. Like you might just have a box that says, number one, something like that. Or you can show it in an example where instead of number one, you might just show an actual number like the number 5 or something. Yeah. So there's two ways to do that. So here's a little more detail on the system figures. So again, they should go from general to specific. Figure 1 should be an overarching system. For example, in EE or computer architecture, you might show a computer with a processor, some auxiliary devices, memory, things like that. Then you pick one of those elements, wherever your invention lives, and then you might drill down on that until you get to where your invention is. The elements of the system should hopefully be broad and conceptual and not tied to any specific hardware implementation. Of course, this is, well, right, even one provided by the inventors, unless the hardware implementation is really part of the inventive concept. So what I mean by this is, you want to provide the context for your invention, but you don't want, unless it's necessary, you don't want that context to be limiting. So you want to be as generic as possible when you show these system elements. And so one good way I feel to draft the text for the system figures is to list the elements of the system, say what they are, say what they physically are, and then say what they do. So, you might say, like, figure 1 is a diagram of a computer, and the CPU processes it. The computer includes a CPU, memory, and an auxiliary device. And then you might say the CPU, the memory stores instructions and data. The CPU processes the instructions to manipulate the data, things like that, right? Yeah, and again, you could talk about the operational flow in the system figures, and you might drill down further, include more detail about what the system elements are doing in this detailed operational flow in the system figures. Again, this can be expanded on in those the data manipulation figures, but I find it good to describe at least generically or generally how the system functions in the system figures. I like to use active voice in all these system figures. It helps to eliminate to improve clarity, and also it helps you establish what system elements are actually performing what operations. If you use passive voice, passive voice tends to eliminate the mention of the system elements, which can be problematic because you might be missing some. You might not be able to claim. You might not be able to do the system claims correctly from that, right? If you say, the triangle is moved to the left, you might not be able to write in. You might not be able to amend your claims to say which element is actually performing that movement. So I tend to avoid passive voice because that, again, you eliminate that. It leads to a lack of clarity, and you might not be able to say what element performs the actions that you're talking about. So again, the explanatory figures include some illustrations of the data transformation that's happening. You can use this to clarify the aspects of the system figure if you feel it's necessary. So I use these to So really to drill down on really the inventive aspects of the application, to really illustrate the features, the operations that are conceptually conceptually complex. And again, you should use active voice here, and you can refer back to the elements of the system figures to explain how the data transformations occur. So the flow diagrams, I like to put these at the end usually, and they're good. Some people use flow diagrams as a means to provide the primary disclosure. So they use flow diagrams as the first instance in which certain operations are described. But I like to use flow diagrams as a way to summarize what is done in the system figures, what's described with respect to the system figures. It helps to if you describe the operations in the system figures, there's a lot that's the actual flow of the operations is dispersed throughout the paragraphs of your system figures, so that it might not be readily apparent what the exact operations that are occurring are. They might be in there in your paragraphs, but it might be hard to it might require a lot of skimming through, a lot of really looking in detail at what those system figures say in order to actually extract the set of operations that constitute your invention. So including the flow diagrams helps to actually distill that language from the system figures into a summary prose that helps you understand what the technique is. And also alongside that, when you do that form of drafting for the flow diagrams, you get the benefit that you can directly support method claims. Since you've distilled the actual technique from your system description, into just sentences that describe what operations occur, it's very easy to take that and actually write your method claims. Again, some people can use the flow diagrams to provide a detailed logical flow, like branching decision boxes, and you might have boxes that link to, like, you might have figure 7a and step 1002 that refers to figure 7b. That's fine. If you want to do it that way, I think that's okay. I avoid that. I tend to find it to be what I tend to do is I have kind of general flow diagrams that just have a few kind of general steps, and then I'll expand on those steps in the specification. And I find that I get the benefit that I can easily explain the operations that occur at different levels of detail. So the figure will have the flow diagram will have the highest level of detail, and then if you say, like, step 1002 includes performing these detailed steps, in some implementations or in some embodiments or whatever, then you sort of get the benefit of the general description, of the technique, but also you get those drilled down specifics of what those individual steps can be. Okay, so I have a poll here. So how do you like to use flow diagrams? Do you do it to just support method claims, or do you use it to describe all of the functional aspects after you've just described the system, or do you use them for some other purpose? Anna, do you have this as a poll?
I do. The results are coming in. We'll just give it a couple more seconds.
Okay.
Okay. I'll give it 5 more seconds. All right, I'm going to close the poll. And I am sharing the results. So Josh, if you can see them, 57% say they use flow diagrams to support the method claims, with 29% saying to describe all functional aspects, and then 14% saying in some other manner.
Okay. Okay, I'm curious if anybody wishes to share how they use flow diagrams in the chat, then feel free.
Okay. Nope, not seeing any comments here.
No pressure. Okay, all right, I'll move on. Let's see. All right, so now that we've sort of gone through how, kind of a general picture of how you can draft the application, I'm going to describe some ways that you might want to supplement the material that you get from the inventors to have a sort of a complete application. So the three ways that I've listed here are that the information that they provide can be too narrow, too broad, or they can miss the whole picture. Of course, let me see here. So the initial disclosure can be too narrow. So, this can happen if for example, the inventors can provide formulas that either describe the entire invention or sort of an important aspect of the invention. And the formulas might be better expressed conceptually because, everybody, I think, has heard the advice not to claim formulas. Formulas can really, it can be easy to design around formulas. And, so often the formulas actually have an idea that's embodied within them that you should probably try to extract. And you can include the formula in your specification, but if you can extract the general idea from that formula, then you can use that to support broader claim language. And this can be difficult sometimes, but I think talking to the inventor, trying to figure out, just sitting there, kind of scratching your head, what does this formula mean? I feel like that's a pretty important thing to do. It's hard to really give guidance about how to do that because it's so fact specific, but I just think that people should be mindful that just including the formula alone can be detrimental. There's also, like, they might also provide code, which again, code tends to be very specific. It'll include some very specific details that are kind of ancillary to the invention, and then it might describe the invention in a way that's too specific. And if you only include the code and maybe even a description of that code, then you might be missing the bigger picture. And so again, you should try to extract the general principle from the code. Another way that the disclosure can be too narrow is that the embodiment described can be directed to the specific hardware context that the inventors are working with, and there might be a more general principle that you can extract from the way that they describe their invention as it relates to their specific hardware. You can include all of that narrow stuff in the specification itself, but the way that I like to do it is to describe those general principles first, and then describe the more narrow embodiments as examples of ways in which the general techniques can be performed. So again, that supports that both covers kind of both ends, and also it supports claiming either the general or specific implementation. The disclosure can be too broad as well, which is sort of a different problem. So it's sometimes the case that the inventors will try to broaden out their invention. Either, I think, I don't actually know that this is true, but I get the feeling that somebody has asked the inventors to broaden out the invention to see what else, to see where else that invention might be applied. And while that broader invention might be important and certainly something that you want to include in the application, you might be missing some details that really might be where the invention lives and might be something that's important to claim. And if the inventors have broadened the invention too broadly, then that might run into prior art. So again, you want to ask, here it's said that you should ask about how their broad invention is being used. But generally you just want to understand what they're doing, what inventor activity actually led to the invention, and what the narrower technique might be, and then you can make a judgment from that point forward whether you should include that narrow description or not. But it's important to just be aware that you want to potentially narrow the disclosure if the initial disclosure is too broad. And again, you can describe this the same way. You can say that the invention is XYZ generic steps, and then you can say X is performed by doing, in some examples, X is performed by doing this specific step. You can do any kind of narrowing language that you want. And then it's also possible that the inventor supplied information misses the whole picture. And there's sort of a number of categories of this, and this understanding this sort of requires some experience with the technology. But by the whole picture, and what I mean is that the invention described material might describe only kind of one viewpoint. One might describe the invention from only one viewpoint. And there's some examples here. For example, for compression and decompression techniques, it's possible that the inventors only describe compression, but really, and they might do that because decompression is trivial once you understand how compression works. But if you don't describe the decompression in your application, then you can't claim it, even if it's trivial. Even if it's a trivial extrapolation from the compression, it's just not going to be supported in the specification. So you should be aware, if you have a compression technique, that you want to claim the whole picture. You want to describe the whole picture, and you want to describe the compression and decompression. It's also possible that the inventor describes a data format. This is very common, actually, and you have to be aware that you want to describe more than just the data format. You want to describe how to generate. You might not want to do all of these things. It depends on the specifics of the application. But some things that you might want to describe are how to generate the data, how to use the data, maybe how to modify the data, things like that. And again, it's very easy it's very easy for the inventors to just describe their data format and send it over to you in their IDF. And especially if the IDF is short, they might just do that. And it's very easy as a patent attorney or agent to just describe that data format in your system. I mean, the worst case is if you combine all those problems and you have a floating invention of just the data format, and then you claim the data format, that can be an issue. So you want to describe the context for the invention, and then you want to describe all of the relevant ways that data format can be used. Again, how it's generated, how it's used, etc. There's also network transactions. So you might be given a description of how something is sent, but you might not be given a description of how it's received and used, but you want to really describe both sides of those things. And it might not have to just be on the network, like a computer-to-computer network. It could be any sort of communication between two elements of a system. You want to describe both sides of that communication if possible. And this is not an exhaustive list. There's probably so many ways that this particular thing can be applied, but it's just very important to take this into consideration when you're drafting the application. So I have a question here. Have you run into any other situations where the inventor supplied material and this is the whole picture? So I guess if anybody wants to put in chat some examples of how the material provided misses the whole picture, other than these examples that I provide, the compression, data formats, and transactions, that could be useful for other people. I don't know if anything's coming in. You can let me know, Anna.
I don't see anything coming in.
Okay, that's fair. Okay, all right, so I'll move on. Okay, so that having been said, I'm going to just sort of include some tips about clarity. So one thing that's really important is using consistent terminology. I think I have that whole slide on that. So obviously, you don't want to be referring. I mean, everybody, I feel like, knows this. This is kind of a technical writing staple, but you don't want to describe the same concept with different terminology. It can lead to all sorts of clarity problems, and also problems with claiming. When you introduce new ideas in your application, you should refer to things that you've already talked about. So already introduced concepts, already introduced terminology, and already introduced figure elements. So it's perfectly fine in figure 8 to refer to system element 302 from figure 3, and you should really do that. And it's perfectly fine to refer to the instruction execution that you described in figure 3 when you're talking about stuff in figure 8, and you should use the same terms there. So I have a rule that I avoid pronouns. You can really lead to some ambiguity, and it's important. I feel like you get the best clarity by just repeating whole words or phrases, to a reasonable extent. You don't want it to be completely ridiculous, but even if you have a 2 or 3 word term, I feel like it's best to just repeat that 2 or 3 word term. And I didn't include this here, but I don't really like to make up my own acronyms and use that because then a third party that's looking at it might have they might be reading your application. The AAD sends the BF to the QRF and have no idea what you're talking about, even though you might have set it up nicely. I feel like it's best to just expand everything out, be clear that way. Another thing that we sort of already talked about related to clarity is that you should explain formulas and code and the ideas behind them. Try not to use technical jargon that's not been explained in the application. Any terms that you use should either be explained or well known. A lot of the time, inventors will provide jargon, and it might be something that's very well known at the client, but it might be something that's completely not known to the external world. And if you use that jargon without explaining it, then that's obviously going to be a problem. I like to just convert even that type of jargon into sort of plain language where possible. But that might not always be possible. And again, this is just sort of goes along with the code, but you shouldn't use something that I see sometimes is that the applications might actually refer to like variable names from the code as part of the explanation. I just don't think that's a good idea. The best way to do it is to go back to the general description of what's being shown in the code and then use the terms from that general in English description rather than refer to the variable names. I feel like if you're referring to variable names from code, it's just, you're going to have clarity problems, especially if you don't describe the code. But even if you do describe the code, I think it's best to just go to the English, words, use the English words for all of your descriptions. So using consistent terminology. So an application builds up the concept of the invention through the incremental introduction and definition of terminology. And terminology is words that aren't readily understood or known by people that are, by the outside world, basically. You should explain those words and terms to the degree necessary to basically write claims from. And you don't have to. Your definitions don't have to be like explicit definitions like this word means this. You don't necessarily have to do that, but you can do definitions sort of implicitly by saying, if there's a system element, you can say the system element does X, Y, Z, and by listing all of the operations that the system element has done, you've defined that system element. Or if you're talking about an operation or a specific step, you might describe, you might say, operation A involves ABC or XYZ or whatever, and then you've defined operation A basically. And I think you should do that to the extent necessary, especially for language that will be included in the claims. For things that are not necessarily central to invention, you can probably be a little bit more lenient, especially if the things are well known. But for things that are going to be in your claims, you should really explain them, define them either explicitly or implicitly. And just the idea of using, this really shouldn't have to be explained, but the idea of using consistent terminology is that you get to reuse, you get to conserve language. You're referring back to ideas that you've already talked about. Then when you bring it up again, you get the benefit of all of that description you've done before. This is sort of a repeat. I'm going to skip past this slide. Oh, one thing that's important is the inventor may provide some initial or supplemental material that includes terminology. And especially if they provide material and revisions, if they provide terminology that's not already in the lexicon of your application, you should translate it into that lexicon. Or if you really need to introduce new terminology, define that new terminology. But that's something that can be an issue is you kind of copy paste material that inventors provide in a revision, and the material does not have the same terminology as what was provided previously. Okay, writing to support the claim. So, the idea is that your specification should be drafted in a way that allows you to easily derive claim language from it. So, you really there shouldn't be material in your specification that really doesn't support claiming either directly or indirectly. For example, you can have words and sentences that can be directly translated into claim language, or you can have words and sentences that sort of explain that language that can become claim language. But you don't necessarily want to include other stuff that really serves no purpose other than the fact that the inventor provided it to you. For example, the inventor might provide results of their experiments, and that may really not be relevant to a patent application. And so you should really think about whether you really want to include that. And again, the claim language either describes structure, so the system elements, or the activity, the steps performed by those system elements. So that's kind of what the types of materials in that you should be writing in your application. Again, use active voice. So we kind of already talked about this. In EE, I like to say that my system elements, where appropriate, can be hardware, software, or a combination thereof. I like to also say that although I've described certain system elements as performing certain functions, the assignment of functionality between those system elements doesn't have to follow, can vary from that. Okay, so again, try to avoid language that serves no purpose, if it makes sense. Let's see. So the last thing I'll talk about is that you can support claims, and I sort of touched on this already, but you can support claims of varying scope kind of explicitly by describing a general description of your invention and then drilling down on the elements of that general description. So again, you can say, the compression technique involves receiving data, processing data, and outputting data. And then, then you can say, like, receiving data in some examples, receiving data includes, and then, X, Y, Z, some specific features. So here's an example. The CPU performs operation 1, 2, and 3, and 4. And in some implementations, operation 1 is performed by performing operation 1-1. In other implementations, operation 1 is performed by doing 1-2. And you can do this kind of recursively so that you can say 1-1 can be performed by doing 1-1-1. This is sort of example language. You don't have to do that. You don't have to be so formulaic, obviously, but I like to lay the specification out this way, so from generic to specific. So here's the summary. So you should aim to fully understand the invention as early as possible. You should use appropriate boilerplate that's carefully tailored for the application. The order that I like to use is the system figures, the sort of explanatory figures, and the flow diagrams. You can include broadening and specific disclosure when necessary. Try to include different scopes for your invention. Make sure to describe the whole picture as you described. Make sure that the writing style provides sufficient clarity, and try to support claim drafting and claim amendments as well as you can wherever possible. And I think that's it. Okay. Well, it's 2 o'clock. So this is over, but if anybody wants to ask questions, you're more than welcome to.
Let's see. That was great, Josh.
Well, thank you.
Okay, I don't see any questions coming in. So that concludes our September webinar. We have, I think, at least 2 more webinars in 2022 plans. I think we are going to do one in October, and we will be sending out information on that when we get it. So check your email. Regarding your attendance here, we take the electronic timestamps and then we report it. So you will be receiving your certificate through email. But I would really appreciate it if you would download that evaluation form and send it back to us. That is helpful. Thank you again, Josh. And everyone, happy back to school, happy fall, and we'll see you again. Bye-bye.